Hello, my name is Nancy Dilliplane. Often families ask what will happen to the money remaining in a trust account, when the beneficiary passes away. The answer to this question depends on the type of trust that you're establishing for that individual. I would like to discuss 3 different distributions depending on the type of trust that is being established, whether it's a third-party trust, a self-settled trust, or a pool trust account. A third-party trust is a trust that is funded with assets that belong to someone other than the beneficiary. These trusts are usually set up by parents, grandparents, or third parties who leave an inheritance via a trust for a loved one who has a disability. The remaining assets in those accounts are distributed to successor beneficiaries that are appointed by the third party in their wills or in the trust document. That is quite different than a self-settled trust, also known as a first-party trust. Self-settled trusts are funded with assets that belong to the beneficiary. These trusts are usually a result of a settlement case that the beneficiary may have received, or an inheritance that's left directly to the client and not via a trust document. In these cases, the beneficiaries can actually dictate or appoint a successor beneficiary. However, because these trusts are also considered to be the personal property of the individual, the accounts are subject to paybacks to public benefits programs that are entitled to a repayment from a client's estate, such as Medicaid. If a client has been receiving Medicaid benefits, the state Medicaid will have a lien on these trust funds, and the trustee must require an accounting and do a repayment of that lien prior to distributing any monies to any of the successor beneficiaries that have been appointed by the client. Also, language must be included in the trust document that will allow the client the power of appointment in their will. If there is no successor beneficiary appointed, then the distribution is made by the trustee in accordance with the intestacy law of that state. A pool trust is a trust account that pulls together the assets of the beneficiaries for investment and management purposes. These trust accounts are usually governed by a nonprofit organization, and there is a master trust and joinder agreements for a third-party trust or for self-settled trusts. The assets remaining in the pool trust subaccount, once the beneficiary passes away, are retained or could be retained up to 100% by the nonprofit. However, not all nonprofits retain 100%. If there's a nonprofit or a pool trust that only retains 50%, the other remaining funds can be used to repay the state Medicaid lien or other state or other public benefits liens that may be allowed to collect from a client's estate. Or if there is no Medicaid lien at all, then the remaining assets will be distributed to the successor beneficiary appointed either in a joinder agreement or in the client's will. Thank you, and please seek legal advice in any matters related to special needs trust.